Tommy V in Michigan. He was on fire this morning.
Okay, thank you, Tommy V in Michigan. Yes, sir. If you share my prayers.
Tommy V's on. Yeah, we'll jump over there.
Tommy V doing great stuff over there.
Edwards. We're ready in that matter.
Nicole Hughes on behalf of the people.
Owen Brown, Deputy Chief Public Defender, appearing with and on behalf of Mr. Edwards. Mr. Edwards is approaching the podium. State your name for the record, please.
I got you. Go ahead, stand up. You stand up.
Good if you want. Okay. State your name.
Luke Edwards Jr.
Today is the date and time set.
Excuse me. I address the court, John.
What do you want? Very quiet.
Can I address the court, John?
I'd advise against it. I've advised him to speak to me first.
You want to address the court, your counsel has advised you that it may not go for you to do so. So
I and my attorney don't see things the same way. So I would, right now, like opportunity to get another attorney.
okay, and how do you intend upon doing that?
I beg your pardon? I'm hard of hearing. Could you put those on? Yeah. How does that work?
Can you hear me now?
Yes, sir.
So with reference to an attorney, how are you intending upon doing that?
I'm going to ask to have another one appointed to me.
Well, it doesn't quite work that way.
Okay.
And this is news to me. I did see Mr. Edwards yesterday, and there seemed to be no issue.
So you've actually talked to Mr. Brown?
In this whole procedure, I may have talked to Mr. Brown, maybe about an hour, 15 minutes here, 15 minutes there, 5 minutes here, 5 minutes there.
Okay.
This is my first time ever being in court in any type of way.
Okay. So what am I supposed to take from you?
That I'm not satisfied with my attorney. And I think I should have.
So what are you not satisfied with?
Our communication, my understanding of anything.
Have you been listening to him?
Yes, I have.
You have?
I've been listening to him.
And you're telling me Mr. Brown hasn't properly communicated to you or with you? Because if you're going to say that, I don't believe it for a minute. He's one of the finest attorneys Washtenaw County has. So you can go ahead and say what you want, but I'm letting you know the perspective I'm coming from.
No disrespect to Mr. Brown.
Oh, you're about to then. Go ahead.
Yeah, that's exactly what I'm saying.
Really?
That I don't understand.
Okay, you not understanding doesn't mean that the attorney isn't doing their job. I don't see a basis upon which to take Mr. Brown off this case. Now, if you want to hire your own attorney, you can go ahead and hire your own attorney.
Okay, that'll be the next procedure that I'll try to do then.
So you're going to try to hire your attorney. How much time you need to do that?
I'm not sure, sir. I don't know.
Well, I got to set a date. How much time do you need? You don't like the best that Washington County may have to offer, and now you want to hire somebody else. How much time do you need?
Well, first of all, I gotta try to come up with some money.
Oh,
Then second of all, I have to have someone to help me find an attorney.
mm-hmm.
Is it a such thing as a promo attorney?
A what?
I may not be pronouncing that correctly, but I'm a lot of dental work done.
Pro bono.
Pro bono attorney, yes.
A pro bono attorney,
Yes.
meaning one that is a good attorney that you're not paying for?
Yeah, yeah.
That's what you want?
Basically, that's what I'm saying. Yes.
Okay, so you realize standing next to you is one of the best that you're not paying for right now. Yeah, I know. I'm shocked.
I wouldn't challenge that. I wouldn't challenge that.
You would?
I wouldn't challenge that. I'm not saying he's not. I'm just saying.
Oh, so now you're not saying he's not.
I've said what I've said.
Mm-hmm.
And
so to the extent that is even a proper motion to permit withdrawal of the public defender's office and Mr. Brown, that motion's denied. I don't see a basis upon which to do it.
So, Your Honor, what I'm going to ask to do is to adjourn this for 1 week. So that,
1 week?
yeah, so that my client and I can have a chance to talk and find out the nature of his discontent.
Probable cause conference will be adjourned. 1 week has what, the 6th? June 6th, 2024. 9 a.m. as your invite indicates, bond will continue. All right, Mr. Edwards, I'm going to make a suggestion to you before you take those off.
beg your pardon?
I'm going to make a suggestion to you.
Yes, sir.
Rather than doing a whole lot of thinking yourself, when Mr. Brown comes and talks to you, maybe you ought to listen to him. And then if you have questions and you may not understand something he's saying, you should probably just ask it. And then you'd have probably a better understanding of what's going on, and we don't have to go through this again. Thank you. Have a great day.
Matthew Manson, public defender, with and on behalf of Mr. James Moody. James, can you state your name for the judge?
James Moody. Thank you.
Thank you, Your Honor. We would like to request a preliminary exam.
Discovery is complete.
My knowledge, yes.
Your Honor, I do know that the 911 calls were requested yesterday in this case. We do not have them yet. Additionally, I did notice that there is on the case ending in 5713, there are videos in evidence.com, but a media notice was not created until this morning. So that has just been, it should have just been released or is being released currently to defense. So on one of the two cases, I do not believe that they have reviewed the videos yet. Or had an opportunity to review the videos yet.
I'm sorry, Ms. Barroso, can you?
So there's
She wasn't speaking French. She's telling you that you don't have the discovery.
Your Honor, from my knowledge, we do have the discovery.
There's two cases. There's one ending in 5708. There is a media notice that already exists on that case. There is no 911 call in my possession, so it cannot be in your possession yet. I made the request for that yesterday. As of the case ending in 5713, additionally, I also do not have the 911 call in that case. So that means that you do not have the 911 call in that case. I do note that there are videos in evidence.com, but a media notice was not made in that case, so they could not have been released to you yet. So you do not have the videos in the second case.
Okay.
That media notice has been created. It has been added to a discovery packet and should be released to you if it has not already been released to you, but I do not believe that in the last 2 hours, you would have had an opportunity to have reviewed that with your client, unless I'm mistaken.
Correct, Your Honor. And if that is the case, then I'm just going to request a 1-week adjournment to be able to review that, and we can go forward with this.
Probably could have done that about an hour. Okay, sir, I'm going to adjourn your matter out 1 week so they can make sure all the discovery gets to you and that you have a chance to see it. It'll be assessed. So June 6th, 2024, 9 a.m.
Your Honor, I do need to address.
Oh, boy. Go ahead. No, go ahead.
So the defendant was arraigned on May 19th. Prior to arraignment, he made 2 calls directly to the victim's phone number. After that, made an additional 39 calls to the victim's phone number directly. Additionally, to the 39 calls directly to her phone number, he had her change her phone number, and he made additional calls to a new phone number that were also to the victim. I have not tallied up the additional calls beyond the 39 that were directly to her, but at this time, I know that there are above 40 or more that happened after arraignment. The victim is the same in both of these cases. I have not had an opportunity to listen to those calls. I did disclose that to Mr. Mansour prior to us coming on the record, but I have not had an opportunity to request for them to be released again. I will do so immediately following the hearing.
Any response?
Your Honor, no response. I did not have a chance to look or go over those calls, so.
Right, but irrespective of going over them, the content is irrelevant if he's contacting me.
That's right, Your Honor.
Defendant's bond will continue as it's said. His phone privileges are hereby ordered revoked. Case People versus Lamar Parker.
Andrew, on behalf of the people.
Good morning, Your Honor. Michael Cobb, P78658. Appearing on behalf of Attorney Allison Fomar for Mr. Lamar Parker. Mr. Parker, would you state your name for the record, please?
Lamar Antonio Parker.
May it please, most honorable court, good morning.
Good morning. All right, what are we doing? Counsel, did a substitution come in? I'm gonna need a substitution from you. I got an appearance. I'll let you go ahead, but I need a substitute.
Correct, Your Honor. I believe that's being prepared. I'll let the attorney of record know. Your Honor, today's date and time set for a PCC. We've been recently retained. It's my understanding that the prosecution is still collecting the discovery. I don't believe the discovery's been complete on the people side as of yet. So I believe we'll need an adjournment. We'll be seeking a lengthy adjournment just because there's some significant legwork to be done. My client, he sustained significant and critical injuries during the same transaction of events from which he was charged. I believe he was offered to press charges himself because of the injuries he sustained. And we'd be seeking to have him give a statement regarding the charges that he's seeking against members present at the time. Additionally, Your Honor, because of the injuries that he sustained and a heart condition that he had previous to this incident, he requires some medical treatment. It's my understanding he's not receiving that. He's on, I believe it's 23-1, he stated. And so he's not receiving any medical treatment for his heart condition or the injury sustained during the event, Your Honor.
With respect to the discovery on this, there isn't quite a bit of discovery in this case. I have seen reports come through as well as media notices about body cams, things of that nature. Those, as we're getting them, are being sent out, but I know I haven't seen an autopsy protocol yet and things of that nature. These things take time, and as I'm sure the court's aware, the county had 4 homicides in about a 6-day span, so there's a lot of work going on. I'm getting that. The second I get it, it's getting turned over. I have no objection to adjournment for those purposes regarding potentially interviewing Mr. Parker. There was basically after the murder took place, there were a number of individuals present and some assaults were committed against Mr. Parker after the shooting took place. He will have an opportunity, if he wishes, to make a statement to the police. I can coordinate that, of course, through the officer in charge. That's not an issue.
Okay. So how much time out are we going to need?
I don't know what Ms. Fulmer's schedule is looking like, but I would think I would be looking at either the 20th or the 27th for an adjourned PCC, at least so we can kind of keep on top of things.
I have Attorney Fulmer's calendar. She was looking for possibly a little lengthier adjournment. I can make myself available if the court isn't.
I'd like you. Sure, you can come back. Well, why don't we do the 20? Why don't we do this? Let's start with the 27th. Let's make sure everything's on track, discovery wise, and everything that it's getting to you. And then if there needs to be a further adjournment, certainly the court can accommodate that.
For the 27th, I know the 20th, her schedule is actually a little bit more open than the 20th.
I have, so counsel, just so you know, I have the 20th, 27th, and July 2nd. I have. So immediately right around that time.
With the July 2nd, does it have to be on a Thursday, Your Honor? Because that's the
July 2nd is a Tuesday.
Okay.
Because I don't plan on being here July 4th. I mean, I will if you want me to come down, but I really don't want to.
I think it might be safest to try for the 20th or the 27th, Your Honor.
All right. That'd be safer for you, you think? Okay. Then let me do that. Probable cause conference will be adjourned June 27th, 2024. 9 a.m. Bond will continue, I believe, as denied in this matter. With regard to any type of medical issue, the court typically does not get involved with that. You'll have to talk to the Washington County Sheriff's Office if there's something you believe that he is not doing or medical treatment. I'm not a doctor, so I don't get involved unless it gets to a certain point. They have medical staff there. If he needs to see medical staff, certainly he can request that.
Thank you, Your Honor.
Thank you. First case, People versus Dolores Strickland.
Good morning, Your Honor. Maria Pamela, Assistant Prosecuting Attorney.
Good, so. Oh, she's not ready yet. No. Got it? Okay.
So Assistant Public Defender with and on behalf of Ms. Strickland. All right, Dolores, can you state your name for the judge?
Dolores Strickland.
Thank you, Your Honor. I was just going to request a adjournment to continue plea negotiations.
Your Honor, just on some background, I don't object to the adjournment. There are a few matters that we should discuss, and I'm not sure about this morning. I received an email pretty late yesterday, saw this morning, indicating to me, it was from an intern indicating that Ms. Strickland has been contacting the victim in the case, at least 2 contacts that we know of. There was also a conversation with her brother, which I'm not so much worried about that contact, but I do want to clarify a few things. So regarding the contact with the victim, of course, that's a violation for bond. I don't have a problem setting it for hearing if we need to. I would ask that her phone privileges be revoked, other than, of course, calling her attorney in their office. Regarding the contact with her brother, as far as I know, there's no condition preventing her from doing so. There are some things that concern me about that contact, including statements by Ms. Strickland that she thinks we're out to get her. She spoke about the prosecutor. I don't know if she was referring to myself or Ms. Willenbrink. It doesn't really matter. Very derogatory terms. Again, we're not offended by that. We get that all the time. However, I want to make sure she's clear that none of this is anyone trying to get her. We don't get any prizes, rewards, any more money. There is no benefit in us going after anyone. What we are passionate about is protecting victims of crime. That includes her children, who are deathly afraid of her, who are scared their mothers will kill them. So her continuing to show up at residents for being in contact with their father, no matter what the background is. And I will say, the social worker did an excellent job from the PD's office. I did review the mitigation report. Officer has done an excellent job of representing Ms. Strickland. Him and I had a conversation about eventually treatment that might be helpful to her. She has trauma in her background. There are specific services. I even sent him a link to a program that I've known the director of, have worked with the director of that program, and I think will be very helpful for Ms. Strickland. At this point, though, the first thing we need to do is get her to follow the orders of this court, because they're in place to protect children, her children. And that's what she should be worried about. So with all of that, no objection to the adjournment. We are trying to work this through. There are no offers at this point. The first thing we need her to do is start following this court's orders, and then we can have a conversation.
Thank you, Your Honor. We have no response to these allegations. We would like to set it for a hearing.
And for the record also, Your Honor, I apologize. I just received the 2 calls made to the victim. My understanding is it involves a debit card or credit card of some sort that belongs to the victim of the case. I haven't had a chance to listen to the calls. I just received them. I will forward those to Mr. Winsor.
Thank you.
So you want a hearing on the phone issue?
Yes, please, Your Honor.
And how long an adjournment did you want?
3 weeks.
Pardon?
3 weeks.
3 weeks?
Yes.
Do you want the
for
hearing
probable,
before that, or do you want?
for the probable cause, Your Honor, I leave that to the court's discretion. The hearing as well.
Oh, thank you. So here's what I'll do, because I don't. Probable cause conference as well as a hearing on her bond violation will be set for June 13th, 2024. That'd be at, let me do 2 or 3.
Let's do 3.
At 3 p.m.
Okay.
So the probable cause conference will be adjourned to the 3 p.m. time. Your hearing will also be adjourned to that time.
Okay.
In the interim, her bond will continue. However, pending that hearing, defendant's phone privileges are hereby ordered revoked.
You can still contact the attorney, us, through
If
that.
she wants to, sure. I mean, yes, she can contact her.
Thank you, Your Honor.
Hold on, let me see that. Okay, it's because.
That's called the case.